On October 30th, 2025, defendant Demetrius Alexander Burks was arraigned in the 84th District Court in Wexford County, Michigan, on a felony charge of resisting and obstructing a police officer, Section 750.81d, alongside misdemeanor charges of assault and battery, Section 750.81, and disorderly drunk, Section 75.167. The charges stemmed from an alleged neighborhood disturbance in which Mr. Burks allegedly approached a family while visibly intoxicated, acted erratically, and initiated a brief physical altercation with the complaining witness, Jordan Dickinson, before fleeing the scene toward a nearby Shell gas station. A preliminary examination hearing was subsequently conducted before the Judge Corey J. Wiggins, with Assistant Prosecutor Lesya Dull appearing on behalf of the People and Defense Attorney Jeff Harrison, representing Mr. Burks. The prosecution called Mr. Dickinson as its first witness, who testified that Mr. Burks attempted to enter his residence. Mr. Dickinson further testified that when he intervened, Mr. Burks struck him and subsequently fled to the Shell gas station. After Mr. Dickinson got off the stand, the second person called by the state was one of the responding officers, Sergeant Zachary Hicks.
Ms. Dell, your next witness.
Can I call Sergeant Zach Hicks?
Sergeant, you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
You may have a seat. Whenever you're ready.
Thank you. Can you please state your name for the record?
Zachary Hicks, Zachery, last Hicks.
Where are you employed?
The City of Cadillac Police Department.
And what is your job with the City of Cadillac?
Police Sergeant.
Were you working on October 30th of 2025 in the City of Cadillac?
I was.
And what were you wearing that day?
That's full police uniform.
Right, and were you driving any vehicle?
A fully marked police vehicle.
Did you have any occasion to come in contact with Demetrius Burks that day?
I did.
And how did you identify him as Demetrius Burks?
He provided his identification card.
And that identification card stated his name was Demetrius Burks?
Correct.
Do you see him in court today?
I do.
Can you please point him out and state what he is wearing?
At the defense table wearing orange.
May the record reflect that the witness has identified the defendant?
Mr. Harrison?
I have no objection.
This will so reflect.
You. So what caused you to come into contact with Mr. Burks on October 30th of 2025?
We were dispatched to an assault and battery complaint at 6. A male carrying blankets had left the area going north from that location.
And was there any report as to where he might be or where he might be going?
Dispatch said just north from that location. Once we got in the area, I briefly made contact with the victim, and he said he thought he was in the Shell station.
Okay, all right. And when you made contact with the victim, was that Mr. Dickerson?
Yes.
Dickinson, I'm sorry.
Yes, that was who was just speaking.
And were you able to get a brief description of what happened from him?
He told me he was assaulted. And
Objection, it's hearsay, and I don't really care about it.
I'm not asking for what was said. I'm just asking if you got a brief description of what happened and a description of the suspect.
All right, I'll sustain the objection. I'll allow the question. Sergeant, if you can just answer that question.
yes.
And then what happened then?
I went over to the Shell gas station where my partner had already started making contact with Mr. Burks.
All right, so your partner made contact with Mr. Burks before you,
Yes.
right? And do you know if the contact was made at the Shell gas station?
I believe they were walking out of the Shell gas station when I arrived on the scene.
And the Shell gas station, is that in the City of Cadillac?
It is.
And that's in the county of Wexford,
It is.
in the state of Michigan?
It is.
Thank you. So what was Mr. Burke's demeanor when you made contact with him, when you approached him?
So I was observing while my partner was talking with him, but he appeared to be, I would call it like a roller coaster of emotions. He was upset at one point, and then he was okay, and then he was upset again. He was obviously unsteady on his feet. He was using the building and the balance. Very slow movements. In my training and experience, he appeared to be intoxicated.
Okay. And you said that your partner and Mr. Burks were coming out of the Shell gas station when you first approached, right?
That's what I recall.
Is that in a public place?
Yeah, it would be right outside in the sidewalk there, right in the parking lot of that area.
And who is your partner?
Officer Bruss,
And who is he, what department is he an officer with?
City of Gallup Police Department,
And how is he dressed?
same as me, full police uniform.
Was he operating any vehicle when he arrived at the location?
A fully marked police vehicle.
So at that point, when you made contact with Mr. Burks, what were you and your partner investigating?
Assault and battery complaint.
And was Mr. Burks a suspect of that complaint?
Yes, he was.
And why was he a suspect?
He matched the description and the location we were told that subject went.
Did he have any items with him?
But he had a backpack and some blankets.
Was that consistent with what the suspect description given to you was?
Yeah.
Now, did Mr. Burks make any statements that confirm that he was in some kind of confrontation with another person that evening?
I recall hearing him saying that he didn't do anything wrong. But while I was standing there observing, me, it sounded like he was in the location where he said he was, where the caller said he was.
Now, at that point, what did you and your partner do?
So Officer Russ told the subject that he was going to be detained while we continue to investigate. He was placed in handcuffs behind his back.
And why was he detained?
He was a suspect in a crime.
After he was detained and the handcuffs were placed on him, what, if anything, did you observe?
Officer Russ started doing an exterior pat down for weapons. Our intention was to put him in our patrol car while we continue to investigate.
And is it your department policy to do a pat down before placing somebody in a patrol car? And why would you do a pat down on a detained person?
To check for weapons. Based on his demeanor and I didn't feel comfortable leaving my partner there with him alone, unrestrained or not in the vehicle while I go further investigate. For officer safety and to check for weapons, that's why he was patted down.
And what happened while he was being patted down?
He started resisting and pulling away, yelling at us. At that point, he was pushed up against the patrol car to gain control so we could continue. And at that point, I advised him to be under arrest.
And what was he under arrest for?
At that point, resisting obstruction.
Do you know if Officer Brust had any injuries as a result of this incident?
He did. He had a scrape on his knee.
And did you personally observe that?
I did.
Just to be clear, this all happened on October 30th of 2025. Okay, thank you.
During the direct examination, Sergeant Hicks testified that law enforcement initiated contact with Mr. Burks because he was the primary suspect in an active assault and battery investigation. Under Michigan compiled laws 750.81d, a felony conviction for resisting and obstructing requires the state to prove a suspect knowingly bucked a lawful command. The statute explicitly defines obstruct to include the use or threatened use of physical interference or force. Pursuant to the landmark Terry v. Ohio framework governing protective frisks for weapons, Sergeant Hicks explained that while Mr. Burks initially complied with being placed in handcuffs for investigative detention purposes, his behavior shifted to active non-compliance the moment officers commenced the defensive pat-down search of his outer clothing. To validate the legal authority of the officer's commands, the record notes that Sergeant Hicks and Officer Brust were conspicuously identifiable in full police dress. Their appearance strictly satisfied Michigan compiled laws 324.1608, which dictates that any peace officer executing a search or arrest must clearly identify themselves via a uniform, badge, insignia, or official credentials, thereby establishing establishing their objective authority to execute a lawful detention. After Ms. Dahl finished her cross-examination, Mr. Harrison began the cross-examination.
Mr. Harrison?
You were the second officer on the scene. Officer Brust, it's Brust or Brust?
Russ.
Brust, I always want to say Brust for some reason. Had already engaged this person, you later determined to be the defendant here.
Correct.
Okay. So all of the testimony that you gave was stuff that you observed. Anything wrong with their interaction up until that point?
What?
Did he appear to be answering the officer's questions?
Sometimes not.
You said, you've talked a lot about his demeanor, but let's call it what it is. He was intoxicated. He's a drunk guy. That appeared to be a drunk guy. And that's how you approach the situation for safety and otherwise, right?
Right.
You behave differently around people you believe to be intoxicated than you might otherwise.
Because I've seen
Sure,
how they can go
right.
very nice and cordial to not nice and cordial.
Or as you've also described it, they exhibit a roller coaster of emotions.
Right.
At some point, Officer Brust put his hands on the person. You described it as a pat down.
Correct.
And that was the point at which he said, "Don't touch me. Leave me alone. Get off me." Words to that effect.
Something like that, correct.
Okay. And your response was you loaded him in the white car that Brust brought to the scene?
Correct. That is the car he went into eventually, yes.
Yeah, it was a white SUV, says Cadillac Police on the side. And then he was presumably taken to the jail.
Correct.
And at that point, he was under arrest for R&O, resist and obstruct. Police officer?
Until further investigation.
Sure, right. Do you recall at any point if Miranda was given?
I don't recall.
I don't recall either. Okay. For what it's worth. Okay, thank you.
Mr. Harrison concluded his cross-examination by questioning Sergeant Hicks as to whether the defendant was advised of his Miranda rights upon being detained. This inquiry focused on the procedural transition from a brief investigative field stop to a formal custodial arrest, specifically highlighting that Sergeant Hicks was the second officer to arrive on the scene and did not personally observe or administer the warnings. Under the Fifth Amendment of the United States Constitution and the landmark ruling in Miranda v. Arizona, law enforcement officers must administer procedural safeguards, specifically advising a suspect of their constitutional rights prior to conducting a custodial interrogation. Under the Fourth Amendment, officers may temporarily detain an individual in the field based on reasonable suspicion that criminal activity is afoot. Because these brief investigative stops are generally non-custodial, Miranda warnings are not required at the inception of the encounter. However, once a suspect is placed in handcuffs, secured in the back of a police cruiser, and transported to a jail facility, the detention surpasses the boundaries of a temporary investigative stop and matures into a de facto arrest. Under Michigan law, regardless of whether law enforcement labels the detention an investigative hold, a de facto arrest demands full probable cause to be considered a lawful seizure under the Fourth Amendment. Because Sergeant Hicks was the second officer on the scene and did not administer or witness the warnings, this line of questioning served a dual purpose for the defense. First, to establish that the encounter had fully transitioned into a restrictive custodial environment, triggering constitutional protections. And second, to lay the groundwork for a motion to suppress any post-detention statements while forcing the prosecution to prove that the officers possessed the requisite probable cause to justify a custodial arrest. Following the excusal of Sergeant Hicks from the witness stand, Judge Wiggins called for closing arguments.
Thank you, Your Honor. Your Honor, I believe by a proven by a preponderance, by a probable cause standard, that assault, resist, obstructing police officer occurred in City of Cadillac, County of Wexford, State of Michigan, upon Officer Brust and Sergeant Hicks, but with regards to the charge, the Officer Brust who was patting him down. Based on the testimony, Mr. Burks was a suspect of an assault and battery. The officers made contact with the victim briefly, got another description and got some description as to where the suspect went. Suspect was found in the exact area where he was told he was heading. The suspect matched the description physically and with the items that were with him. Brooks matched the description given of the suspect. Officers made contact with him. He made some statements. He looked intoxicated. Officers then detained him to get more information and have further conversation with the victim and investigate this crime. While he was being detained, he was handcuffed and patted down for weapons for officer safety. Sergeant Hicks testified that he did not feel safe to leave Mr. Burks based on his demeanor alone with another officer to try to further investigate this crime. And as Mr. Burks was being detained, he pulled away from the officers as he was patted down. And that was the resisting the officers' lawful acts in investigating this crime, the assault and battery crime. Which resulted in him further resisting from the officers after he was placed under arrest for resisting. So I believe that the people have proven by a probable cause standard that the crime occurred. Both the victim of the assault and battery and the officer identified Mr. Burks here in court as the person who was involved in the incident on October 30th of 2025. Thank you.
Mr. Harrison?
It seems to me what we had here today was an individual who was intoxicated, who denied being involved in the underlying crime and wasn't terribly excited about being taken into custody for a crime that he asserted he didn't commit. I guess if you look at the statute, it doesn't take much to commit or resist and obstruct a police officer, but there were two of them. One of him, he was already in handcuffs, and by the officer's own testimony, he was placed in the police car and taken to the jail. I don't think this rises to the level contemplated by the statute that will constitute the felony charge here that's been lodged. Thank you.
During closing arguments, Mr. Harrison argued that the prosecution failed to establish probable cause to bind over the felony charge of resisting and obstructing. Under MCL section 750.81d, while the legal threshold for resisting and obstructing a police officer is broad, the defense argued that the essential statutory elements were not met in this specific context. Mr. Harrison pointed out that Mr. Burks was an intoxicated individual who vehemently denied any involvement in the underlying assault. His physical reaction was not an act of active aggression, but rather constituted passive, non-violent resistance from an individual protesting his innocence regarding a crime he asserted he did not commit. Furthermore, Mr. Harrison highlighted the factual realities of the encounter. There were two police officers managing a single suspect who was already restrained in handcuffs. Because the officers easily maintained control and quickly placed him into the police cruiser, the defense maintained that Mr. Burke's minor physical resistance did not amount to the physical interference or force contemplated by the statute and requested that the court dismiss the felony count.
Mr. Harrison is correct that it does not take much to rise to the level of a resist and obstruct. We also look at that from the angle of whether what the officers were doing were lawful. Sergeant Hicks had testified that the defendant was placed in handcuffs behind his back as a detention purpose. This was essentially because of the assault that had happened, or the alleged assault that had happened earlier. And then a pat down begins, presumably looking for weapons that may be on, or other instruments that could harm the officers. However, there was no reasonable articulation as to why they suspected Mr. Burks to have weapons. It was a fisticuff fight. There were no threats made as far as using weapons. Had the pat down occurred before he was placed in handcuffs, that might be a different situation. But once he's placed in handcuffs, I believe that the threat is more removed, and without the reasonable suspicion that he was was armed in some way, I do not find that the pat down would have been lawful. And as such, I do not find that the people have met their burden in count number one, and the court will dismiss that charge without prejudice. The case will go forward on the assault and battery and disorderly drunk.
Judge Wiggins determined that the prosecution had failed to meet its evidentiary burden as to the felony resisting and obstructing charge, focusing on the fact that there was no lawful basis for the officer's initial pat-down search on the record. Accordingly, count 1 was dismissed without prejudice, while the lesser misdemeanor counts were permitted to move forward. Concurrently, the court modified the defendant's pretrial release conditions, reducing the bond from a $10,000 to a $5,000 bond under the same standard conditions. This case illustrates an important judicial judgment in a preliminary hearing. Because Mr. Burks was detained and showed no signals of weapons during the encounter with Mr. Dickinson, Judge Wiggins found the pat-down search was executed unnecessarily after he was already secured in handcuffs. Accordingly to the judge, when Mr. Burks was handcuffed, the legal foundation for the felony vanished, and the prosecution could not proceed. The requirement for reasonable articulable suspicion before executing a weapons frisk exists as a vital safeguard designed to ensure that the government adheres to the same constitutional standards that it is sworn to uphold. Now, let us know if there is a case you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe for more videos.